I'm gonna for Mama Kwaba the bank Kasa TV. And I know first time I share Kasa TV. I'm sure say, but like now subscribe, no share, so every time you have fresh news updated, you know who the air console my name. Now I'm gonna for a brand NDC for Abefi, Akuna Swana, Art.459 Opuni, Ekofa, Lipiton fertilizer, a semi copie mo ewo. Accra High Court na anya asem ketwa omo ye koba Accra High Court to me anso asem nim ana aka sa ya asem na ko pie wo Supreme Court no nom Ghana fo na Chief Justice as set up a 5-member panel about some bra no be di asem no nom Ghana fo mo ye ya court to me and ya hearing bia na say hearing bia to me MP ana Chief Justice here na do say obese sapano no and of sapano no na behwe Opuni NDC for say hey identity Chief Justice as sapano no identity Chief Justice as sapano no na so article 459 just the Chief Justice to me sapano say court enya hearing bia na say bia to me ankoso a Chief Justice to me sapano and the media say hey it looks like Art Opuni person or tarnish the image of the Supreme Court. Now so I'm Ghana for justice has been made and as a justice approve say yes embra or my name tia sembre no yakuna ko tie sa samu etwam mbra medamase
practice what the matters are. They just come and say that Chief Justice has changed panel and they suggest somehow or rather that something untoward is being happened. That situation is quite dangerous and the Attorney General referred to it. So with our understanding of Article 1573 now, let's go and look at the statement that was issued by the Attorney General in respect of this matter, and it is as follows. General and Ministry of Justice, a press release. Attention of the Office of the Attorney General and Ministry of Justice has been drawn to the deliberate misrepresentation in the media, traditional and social, about the composition of a panel to hear an appeal in the Supreme Court in a case entitled The Republic versus Dr. Stephen Opuni and others. Publications in various newspapers, particularly the Herald, and commentary on social media by some persons, including Kweku Asare, are laden with falsehood and contain imputations that the composition of the panel for the hearing of the appeal on 8th May 2024 was unusual, questionable, or in violation of the Constitution. The Attorney General and Minister for Justice, a party to the case in question and owing a constitutional duty to protect the administration of justice from abuse, hereby sets the record straight. And it's as follows. 1. Arguments in the appeal filed at the Supreme Court by Dr. Stephen Opuni against an order of the Court of Appeal dated 3rd July 2023 for adoption of evidence led in the case mentioned above were heard by the Supreme Court on 8th May 2024 and not on any date before. The Attorney General is speaking to the article that we saw, and he's saying that the arguments were heard on 8th May. It was never heard before. No arguments were made before. Number 2, he says the appeal was originally listed for hearing at the Supreme Court on 17th January 2024. By that day, no written submissions had been filed in the matter. A bare notice of appeal was the only process that had been filed in the proceedings. The Supreme Court also did not invite any of the parties to make oral submissions, either in the support of or in opposition to any of the grounds of appeal filed by the appellant. It is thus undisputable that no arguments were heard by the Supreme Court on the 17th of January 2024. Now, in this paragraph, I believe that Attorney General is showing that Article 157 has not been violated. So he's giving the dates and the timelines and showing when arguments were heard and when arguments were not heard. Remember that after arguments had been heard, a judge cannot withdraw from the matter. And now the Chief Justice has exercised her discretion to change the panel. Here we are, the Attorney General explaining that at the time the Chief Justice exercised that discretion, she was not in violation of Article 157 because it's a matter of dates. Whether arguments were heard on this date or whether arguments were not heard on this date, lawyers for both parties have the same calendar. The dates that the Attorney General is speaking to is the same date that the Opuni lawyers will speak to. No one can be dishonest about dates because it's mathematical. 7 January, 7 January. If something was filed on 7 January, it was filed on 7 January. The record will show clearly. So everything that Attorney General has written in statement about dates, I believe that Opuni's lawyers can write the same thing because dates cannot be manufactured. All right. Number 3 is the court rather gave directions for the future hearing of the matter by ordering the appellant, Dr. Opuni, to file his written submissions within 21 days, and the respondent, the Republic, to file her written submissions within 21 days of being served with the appellant's document. The parties, this paragraph 4, the parties duly complied with the directions of the court, and the appeal was subsequently listed for hearing on the 8th of May 2024. On that date, the panel for hearing of the appeal was reconstituted by the Honorable Chief Justice in exercise of her powers under the 1992 Constitution. So on the date that the parties came, the Chief Justice reconstituted the panel. So she reconstituted the panel before any submissions could be heard, or before any submissions could be read by the panel that was existing before. I think that is clear, isn't it? All right, let's move on. Paragraph 5. Counsel for the appellant, Dr. Opuni, citing Article 1573 of the Constitution, raised a grotesque and wild objection to the reconstitution of the panel, and in fact insisted on the previous panel hearing his appeal. The Attorney General prayed the court to dismiss the objection as misconceived by alluding to the matter set out above, and noted that the operative words in Article 1573 of the Constitution are, quote, "No person sitting in the superior court shall have heard the arguments of the parties to the cause of matter, and before judgment is delivered, withdraw." No person shall have heard, and before judgment is delivered, withdraw. So the person, the judge, must have heard the arguments, and then he says he's withdrawing before the judgment is given. That the Constitution prohibits. A judge cannot do that. You cannot hear the arguments. You hear the arguments as a judge and then say that I've withdrawn. If a judge has heard the argument, the Chief Justice is precluded from changing the judge at that time, unless for some clearly stated offense or something like that. But otherwise, the Lord Chief Justice cannot exercise her discretion when a judge has heard the matter. In the instant case, Attorney General is pointing out that the panel members had not heard the matter, and therefore Article 1573 had not yet kicked in. Anyway, let's move on. He says further, there had been neither oral nor written arguments in the matter heard on 17th January 2024, and therefore Article 1573 was not triggered. The court, after considering the submissions by both counsel, overruled the objection. The Attorney General notes the persistent attempts by some media houses aligned to Dr. Opuni to distort the effect of court proceedings relating to the prosecution of the former Chief Executive of the Ghana Cocoa Board. These publications, many a time, Attorney General says, are a gross misrepresentation of the evidence led at the trial, intended to ridicule the case of the prosecution and create false impressions about the soundness of the defense put up by Dr. Opuni at his trial. The Attorney General observes that most of the publications on the Opuni case, orchestrated by the accused persons themselves, transgresses the limits of permissible speech, and they are calculated at perverting the course of justice and or prejudicing the fair hearing of that case. Nonetheless, the Republic being the Attorney General's department, remains focused on adducing cogent evidence in substantiation of the charges against all the accused persons in the case mentioned above, and will not be overawed in that process. For the purpose of educating the public, the Attorney General states that no party to the proceedings in the court has a right to insist on a particular court or panel of courts to hear his or her case, in accordance with the Constitution and the Courts Act 1993 Art.459. The Chief Justice determines the compositions of every court for the hearing of any matter. The Chief Justice is a member of every court in the country and has the power to request in writing a justice of any of the superior courts of judicature to sit on either the Court of Appeal or the High Court at any time. Further, consistent with Article 128, the Constitution, the Chief Justice presides at the sitting of the Supreme Court. Now, this is an important matter that I think I have to emphasize on. The 1992 Constitution allows the Lord Chief Justice to be a member of any court at all. So the Chief Justice can on Tuesday go to the Circuit Court by a letter and say that the matter of Paul Adomotri and Captain Smart, I want to be the judge. She's entitled to do so. Justice Akufo-Addo did it many, many times. Some of the famous decisions, especially what the lawyers call Musi and Bajina, ruled by Justice Akufo-Addo, he did it as a High Court judge. As a Chief Justice, it was a High Court decision. And he was sitting as the High Court judge. These things are in the Constitution. Every lawyer knows it. But sometimes when the lawyers come on social media or even on regular media, they do not speak these things because they know the journalists don't know it. And then they try to